Hello, hooray, thank goodness I'm here again. It's Thursday. It's a wonderful, wonderful Thursday afternoon. And as usual, I have some, we were spilling some tea the last time. So we're just going to continue with what we started discuss, what we've been discussing for the past few days. We're still discussing, RFEs and notice of intent to deny, which is the NOIDs. Hello, guys. Welcome. I hope you're all doing great. I'm still dealing with a horrible cough, so please bear with me if I stop to cough or drink some tea during the video. All right, guys, so we'll just jump into it. For my YouTube viewers, as always, as you can tell, this is a new channel. Please show some love, show some support. Give me a thumbs up, subscribe to my channel, like, share, comment, and a very special welcome to you and to my Facebook family. Come on in and join us if you are available. As always, we're trying to keep this very short and sweet, and bearable. So yep, here we go. I'm just going to go right ahead to share. No, I think I need to fix this before I share my screen. Welcome, guys. Welcome. I'm just trying to zoom in so that you guys will see everything. I'm so sorry. I have a really, really bad cough. Welcome, guys. I'm really excited that you guys are here. Of course, I do the live video so that I can interact with you all rather than do the pre-recorded. I think the live gives me a chance to, see who's watching and actually get to know you guys a little bit better. Okay, so let's continue. Today, we're actually discussing something known as statutory declaration. Okay, so we're discussing statutory declaration. I'm sorry. I've actually been working on a case this week where we've been, trying to resolve some statutory declaration, a marriage-based green card where there was a dissolution. And so I'm sorry, statutory declaration has been part of my vocabulary a lot this week. So no, we're not talking about statutory declarations. We're going to be talking about statutory denials. Statutory denials. The law is very interesting. That a ton, like millions of terminologies and technical words, and everything has a meaning and a standard, and so that's just by the way. But we're dealing with statutory denials. This also comes under the RFEs and NOIDs when you file any type of application to the U.S.A, which is the United States Citizenship and Immigration Services. They may respond by either asking you to provide more evidence or telling you that, look, we're about to deny you. We've received some derogatory information about you, or we have found some derogatory information about you. That's the NOIDs. So we're about to deny you. Do you want to, counter it? Do you want to rebut it? Do you have anything to say in your defense, or, anything that can make what we found better, or whatever? Your last chance to actually respond to us and convince us that we should give you the the application. I'm sorry, the request that you are seeking. So this statutory denials comes under it because this may be a response to your application, and this is how it affects you, that you may receive a statutory denial when you file any type of applications to the U.S.A. So let's see here. A statutory denial should generally be issued without prior issuance of an RFE or a NOID on any application, petition, or request that does not have any basis upon which the applicant, petitioner, or requester may be approved. Okay. This would include any filing in which the applicant, petitioner, or requester has no legal basis for the benefit or request sought, or a request for a program that has been terminated. I think we discussed this the last time, so we'll go a little bit more into details. I'm sorry. So essentially, when you file an application and you have no basis, you're going to get a straight out denial. So for example, you're a guy and you live here in the United States, and you happen to be a US citizen, and then you have let's say a wife, but then you have a sex buddy, you know, somebody that you have sex with. Some people have those kinds of relationships, a sex buddy, and then you file an application. Your sex buddy happens to be a foreigner who is out of status or undocumented. Then you file an application to the U.S.A, and you tell the U.S.A that, look, this is my sex buddy or sex partner, and I'm filing because I'm a U.S. citizen. I'm having sex with this person, and so I want you guys to adjust the person's status. There's no legal basis for that type of nonsense request, right? You are going to receive a statutory denial flat out. They're not even going to waste their time to issue an RFE or a NOID, because there's no point issuing you an RFE. There's no evidence on this planet that you're going to submit for them to approve such a request. And they don't even need to inform you that they're going to deny you. So that there's no point in issuing an NOID to you, because this is a very bogus and baseless and unsubstantiated request, and it will flat out be denied. And so that is known as a statutory denial. The last time I gave an example of, you know, somebody trying to file for, as a U.S. citizen, trying to file for, let's say, your grandfather, or a grandfather trying to file for, you know, the grandchild. There's no such immigration benefits, and so that you'll receive a statutory denial. And then sometimes there are programs that have been terminated. So, for example, I think adjusting under the under Section 245I, this ended in 2001. This was where people could adjust their status based on certain requirements under Section 245, and it's been terminated. So if you file a current status and say you are trying to adjust under 245, you're going to receive a flat out statutory denial. Okay. And let's say your mom is a U.S. citizen, she has a boyfriend, and then you are also a U.S. citizen. You decide to file for your mom's boyfriend. There's nothing like that. So, guys, you get the picture. That's when you receive a statutory denial. Waiver application. So these are examples. I don't know why. So I'm actually still using the policy manual that was issued, I'm sorry, by the USCIS. And so we've gone through the entire policy manual, like the policy memo that was issued. And this is the final section of the policy memo. And it looks like they've done a little bit of repetition. But yeah, we'll just go through some of this and then see if we can have some more examples, and then that should be it. So waiver applications. So these are examples. That waiver applications that require a showing of extreme hardship to a qualifying relative, but the applicant is claiming extreme hardship to someone else, and there's no evidence of a qualifying relative. We discussed this in the previous videos, guys. Take a look at that. Family-based petitions filed for family members that are categories that are not provided by statute on the claim family relationship. So here you can file for your nephew. You cannot file for your, you cannot, as a U.S. citizen, you cannot file that, okay, I'm filing for my nephew specifically. The relationship, the basis of my filing is uncle-nephew relationship, okay? So that will be denied. You're going to receive a statutory denial, okay? And then I think, yeah, we did address this. Officers should check the applicable policy and operating procedures for, of course, additional guidance. Okay, let's just go to the bottom and then make sure we're done with this document. And then tomorrow when we come, I'll be looking at other, this is interesting. Yeah, we did all this. Yep. Denials based on lack of sufficient evidence. Okay, let's just go through this quickly, just because I just want to make sure we've covered everything. I don't want to jump over anything. I want to make this as comprehensive as possible. I'm sorry. So denials based on lack of sufficient initial evidence. In the case of a filing that lacks initial evidence, the application may be denied without issuing an RFE or a NOID. Remember, we discussed this. Examples of filings may be, waiver applications submitted with little to no supporting evidence. So there are certain type of waivers, and so you can file because you're trying to waive fraud, or waiving misrepresentation, or waiving your inadmissibility. And so you need to attach supporting evidence to that. Okay, and then sometimes you're filing these waivers because there'll be undue hardship to a qualifying relative. So all of that has to come with supporting evidence. If you're saying that, oh, I have a child here in the US and the child has some disability, and so if you deport me, it's going to cause undue hardship to my US citizen child who has perhaps a disability. You need to file with the supporting evidence. What is that disability? How are you so attached to the child? What are just prove what you're saying with documentary evidence. That's what they're going to be looking out for. All right, guys. So cases where the regulations require submission of an official document or evidence that will establish eligibility at the time of filing and there's no submission. Okay. So of course you have to submit. So for example, here they give an example of the I-864, which is the affidavit of support. If you are filing a family base, sometimes you might need that to show that there's a US person, either a green card holder or a US citizen who is willing to stand in for you and to support you financially if there's any problem. I'm sorry. So let's go to the final part of this. The final part of it is right here. Yep, right here. Good. So now we're going to be talking about NOIDs specifically. Guys, drop me a comment. I'll be reading some comments very soon. Notice of intent to deny. A NOID may be based on evidence of ineligibility or on derogatory information known to the U.S.A, but the applicant is either unaware of the information, number one, or may be unaware of its impact on eligibility. So a NOID is simply bad information about you. I think we addressed this last time too. Bad information or negative information about you that the U.S.A finds out, but then you don't know about the information or you're unaware of the impact on eligibility. So it's funny, but sometimes when people file applications, they do transactional marriages, for example, and they pay, there's an exchange of money. And then they, let's say they tell a friend, and then they fight with a friend. The friend may sometimes call the U.S.A and say, look, so-and-so's application is a transactional marriage. She paid money. I'm attaching evidence of this, of this transactional relationship. She told me that she paid money to so-and-so to file a marriage-based green card. The applicant will not be aware that his friend has called the U.S.A to report fraud. Okay, so the U.S.A, what do they do in response? They will issue a NOID that, look, this is the information we have about you. And then the petitioner is shocked because they didn't know that the U.S.A had that information. There are just so many crazy things happening out here. So, you don't know who's watching, listening. So some of these things happen, and when there's an adverse, when an adverse decision is based on derogatory information, then of course you have an opportunity to rebut that information. That's why the NOID is issued. Like, look, rebut the information that we have. In that situation, a NOID provides an applicant with adequate notice and sufficient opportunity to respond and the opportunity to review and rebut derogatory information of which he is unaware. Okay. While not required in other situations, the NOID also provides an applicant, petitioner, or requester with adequate notice and sufficient opportunity to respond to an intended denial on other substantive grounds. So here you'll be given an opportunity, like, oh, you can respond legally to the U.S.A and tell them, look, that never happened. My friend is fabricating. Here is the evidence I have. Here are some more bona fides. Here is what happened. Here is so. Here is so. And such NOIDs should be taken very seriously and be addressed very adequately. Okay, so that you can convince them that that is bogus information. Okay, so when a preliminary decision has been made to deny an application or petition and the denial is not based on lack of initial evidence or a statutory denial, and 8 CFR 1032B16I applies, the adjudicator must issue a written NOID to the applicant, providing up to a maximum 30 days to respond to the NOID, and they must include the required response date. So just like the RFE, you know, they'll tell you, so here it's not because of lack of initial evidence, or it's not a statutory denial. The NOID is just simply has to do with derogatory information, okay, that the USCIS finds out about you or your family or your case that makes you ineligible for the benefit that you're seeking. So usually they would provide 30 days for you to respond to the NOID. And the reason they're not going to issue an RFE is because no evidence. So it's not, it technically will not be called an RFE because they're not requesting an evidence. They're just giving you an opportunity to rebut that evidence that they have received about you or the information they found out about you. All right, guys, I think this is the end of the document. Let me just scroll down and make sure that we've covered everything that we wanted to cover. Okay, yeah, pretty much. Oh, okay. Yeah. Yeah, we can probably talk about the use of this policy manual, and then we'll call it a day. As you can tell, oh my goodness, I feel really I'm a little bit under the weather. So this policy manual is intended for training the guidance of the USCIS workers in performing their duties relative to the adjudication of applications and petitions. Okay, so see, this is what we're using. This is like the marking scheme, and just to give us all the information so that we'll be able to prepare adequately for any type of application that we're trying to file. All right, guys, so I think we'll call it a day. I just had to pass by today and then chat with you about RFEs and NOIDs and statutory denials and, you know, derogatory information and all of that. If you have an RFE or a NOID you're trying to respond to, call me. My number is right there, 802-7800-564. And I will be happy to assist you. You will book my assistant. She's very friendly. You speak with her. And then you book a prepaid consultation to get a slot on my calendar. And then that'll be my special one-on-one time with you. I'll review the information and see how we can attack it and from what angle we attack it. It's really important because everything in this country revolves around having proper documentation. And oh my goodness, don't mess that document up, because when sometimes you handle some of these things yourself and you mess it up, it becomes extremely costly and extremely difficult to undo. Sometimes it's not. Sometimes some people wish they would even be charged $50,000 just to undo what they've done, what the harm they've done. But sometimes you just cannot even pay for the mistakes with money. So yeah, be mindful of that. You need your peace of mind to be able to live and work legally in the US. So contact me if you need help with your US immigration law issue. Don't take it lightly. The least mistake will have you paying dearly for a long time. All right, so guys, I handle all types of US immigration law matters and serve clients all around the US. So I will be waiting to speak with you. Olamide Adibayo, welcome. I'm really happy you joined us today. I hope you are doing great. I will see you guys again, hopefully tomorrow. So be good and stay safe and show some love to the people around you. All right. Oh, today I forgot to show you guys my wings. I have some. I just love my outfit today so much, but yes, that's the only part I can show you. So I'll see you guys again tomorrow. Be good and stay blessed. Okay, bye.